Statewide Information Security and Privacy Office, and we are very appreciative to the legislature that we have our office, because the office came into effect in 2007, and we are a forerunner among the 50 states to have our office, in that we have combined the force of information security with privacy. So you will be hearing from our manager of the Statewide Information Security and Privacy Office, Jim Ryan, after I get through my slides and take any questions. We're also very fortunate to be placed within GITA. As a strategic information technology agency, a lot of processes have been placed through policy that deal with information security. But now what we're looking at, and what the statutory authority in Arizona Revised Statute 413507 provides for, is to respond to this ever-evolving cyber world that we're dealing with, and also implement something that has not been dealt with generally in state government or government in general, and that is a culture of privacy. And I will go into this a little bit more. It's not that we don't respect the privacy of individuals, but it is something where we become more consistent with how we handle information and how we allow individuals to know how their information is being handled. So with that, I will go forward here. One of the first things we wanted to look at when we started with this information security and privacy concept is, okay, what relationships are we balancing? Just kind of by way of background, we're looking at the prior approach to business and government, in that we're going to collect any information that we feel we need for business. And that's why I put the need in quotation marks. Then came along a question of, what do the citizens really expect as far as what's collected and how it's protected? We've seen that through the evolution of the Privacy Act, the federal level, and we've seen that through the Health Insurance Portability Act and a variety of other evolving, generally federal legislation. We have that on top of it balanced with legal requirements that have generally come through court cases or other statutes that say, okay, you can collect that information, but you can't redisclose it, or you can only redisclose it in this manner. One of the biggest challenges we and every other state have is, how do we define what's personally identifiable information? For example, we know that health information is just about, consistently everyone would say, yes, that should be private information, only used for healthcare purposes, and even then, some, limitations on that. So I have up there that we have a static definition, in that there are certain elements that everyone agrees on, like Social Security numbers, although there again we have some exceptions, thanks to the federal government. But anyway, for the federal folks, we understand your pain. But we also have this evolving need of what other information may be required to assist, in our case, the citizens of Arizona to collect information that maybe wasn't collected because we have a new program in place. So let me give you a bit of an example here. We have 3 state statutes that are, we'll call them statewide, enterprise level. One deals with breach notification. Very important statute. CISPO, our Statewide Information Security and Privacy Office, was enacted to respond to the identity theft that occurs within Arizona. I don't know how many know that we in Arizona, not saying state government, but just in Arizona, through the statistics of the Federal Trade Commission, have found that we're #1 in identity theft. And so the legislature, being responsive to this, said, okay, let's put in the Statewide Information Security and Privacy Office. Let's develop more enhanced response to information security, and develop an approach to privacy that not only enhances our protection of whatever is personally identifiable information, but also lets the citizens know what their rights are, to know what information is being shared, what they can access, and if they have a concern about it, who they can go to. So our breach notification statute deals with the protection of information that is an individual's name in combination with a social security number, their driver's license, a non-operator's license, or a financial account number with a password. Now, if any of that information, if it's kept electronically, should end up in unauthorized hands or misused, that's a breach. And that means that we as a state are to notify the citizens whose information was compromised. Now we have, again, that's only electronic information. Now we have about probably 60%, and that's not a hard statistic, but it's observational, of our business at the state government that is based on paper. We have a very important state web portal that is helping us transition safely hard copy information to electronic information, and Mr. Andy Miller will be talking with you a little bit later on that. We then have another statute that talks about the appropriate disposal and destruction of personally identifiable information, and that statute defines personally identifiable information identically as the breach notification statute, with one exception. That statute deals only with paper records, not electronic records. So we have a disconnect. Then we have a third statute that's called the anti-identification statute. And this statute is really, it was enacted definitely to respond to the identity theft concerns and safeguarding information, but it then expands the list of personally identifiable information to be business address, a business taxpayer number, a bioidentifier, an individual's address, a date of birth. It's about 60 different identifiers. And the challenge that we have with that in our agencies is it overlaps and goes beyond those other two statutes. It appears to apply to both electronic and hard copy records, but to ask our agencies consistently to say that a taxpayer ID is not to be disclosed, or that it needs to be protected always in a certain manner, that just isn't the standard practice. So what we are doing is looking at what authority we have here in Arizona, looking at our citizen data, looking at what would personally identify an individual, make sure that, okay, we are consistent with knowing what it is we can collect, use, and disseminate, develop safeguards and additional safeguards consistently across the agencies. And we are happy to help all of you, too, in the legislature. And we're working with the courts, we're working with the universities collaboratively to say, okay, this is the universe, if you will, of personally identifiable information that really, really needs to be protected and needs to be encrypted and needs to be not disclosed unless either the citizen authorizes it or we have authority to authorize it. And then we need to communicate those practices so that the citizens know, and that's all of us in the room, what are basically what the information practices are for the state of Arizona and how they may learn more about those practices and have a say in those practices. So that's really kind of setting the landscape of what privacy is. Privacy is what are we authorized to collect, and why do we collect it, and why do we redisclose it? And then Jim will be talking about how we protect it, and that's where we get into at least the cybersecurity part. My job involves how do we protect it while it's still in paper and collaborating with information security, because the more we can transfer over to the electronic world, the more we can identify that personally identifiable information was adequately protected through audit logs. We identify who had access to it, and we can ensure that we do have an envelope protection, if you will, through encryption or other methods of electronic safeguarding. In Arizona, we have a very high awareness of confidential information. We have numerous confidentiality statutes, but they're mainly agency specific. And that's a good thing, but it also raises conflicts with, again, identifying what should be protected information, what should be perhaps sensitive information, protected in certain circumstances, and what's really all public record. The few statewide confidentiality statutes, which I just mentioned to you, the destruction statute, breach notification statute, and the anti-government identification statute, show the inconsistency, because every time our legislature is confronted with an issue, you're working with your stakeholders. This is the issue, this is the problem, and the problem is addressed. What we need, like every other state, move forward is looking at the larger picture, talk to the experts, talk to the resources to say, what have we done in the past on saying, you know, this information should be protected or how it's protected. And then we can provide advice on coming up with more consistent definitions of what really needs to be in the top tier of, let's say, always protected information, again, kind of like a middle tier of sensitive information, and then the public record tier, because once we have that, we will have the ability to, through a cost-effective approach, meaning consistent, repeatable processes, know what needs to be handled in certain methods and what can be handled in the normal, ordinary course of business. When we have a lack of consistent policy and structure, we cannot communicate how to handle the job and the information that needs to be handled by an employee or a contractor. They don't know what their responsibilities are. And I'm not saying it's a complete void here. It's just been inconsistent. It's been fragmented. And this is very normal from a federated approach, which we have. We have agencies that have their own authority, very good, very important, but they need help in having an overall guidance. To take this step further, we needed to look at the landscape of a state of Arizona from a privacy perspective. This has not been done in any other state. Again, we're ahead of the pack thanks to all of you, starting with the Statewide Information Security and Privacy Office. So we conducted a privacy assessment. We did it kind of an initial mode. I don't want to call it a test, but in a way it was somewhat of a, let's do a smaller scale. Let's look at 18 agencies, small, medium, and large, and let's apply a generally accepted privacy principle questionnaire, self-assessment, to identify where these agencies are in their privacy culture maturity model, so to speak. So it's a self-assessment. This is being used and was developed by the American Association of Certified Public Accountants along with their Canadian counterparts. The tool is that this assessment evaluated and asked questions on the organization and the approach to privacy in each agency, its collaboration with information security, what notice of information sharing it would provide citizens. Do citizens have a choice of consent over information that is redisclosed primarily? We have authority to collect our information in our agencies, but what about secondary disclosures? How we collect information, could it come, was it duplicated? Were we collecting the same information, the same agency, but collecting, you know, just different divisions collecting the same information?